Matt, I believe we can go live now.
Thank you. The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to this virtual sitting of the Massachusetts Appeals Court. It's September 13th, 2022. My name is Mary Sullivan, and your panel today will consist of me, Justice Blake, and Justice Grant. We are hearing one case virtually today. We completed our other cases earlier this morning, and that case is 21P0695, Commonwealth versus PEREIRA. And is it Attorney Arter?
Yes.
You may proceed.
Thank you. Good morning, good afternoon, Your Honors. My name is Corey Arter, and I represent Mr. PEREIRA in this matter. This is an appeal, as I'm sure you're aware, a direct appeal of finding of a violation of probation out of the Brockton District Court. The basis of the appeal, the grounds for the appeal are threefold. One, it's our position that the violation of probation was based solely upon the two new offenses and the hearsay statements introduced contained in the reports of those two offenses. Two, it's our position that the trial judge violated Mr. PEREIRA's due process rights to confront and cross-examine witnesses against him without a finding of good cause for the failure of the witnesses to appear. And finally, that the hearing judge failed to provide written findings of the violation hearing. If I may just very briefly on the procedural background and why it's our position that the violation was solely based on the new offenses and the hearsay statements. If you look at the history and in the appendixes, you'll see that Mr. PEREIRA was placed on probation in 2019 in the Brockton District Court. In January of 2020, probation violation notice was issued to Mr. PEREIRA for failure to report on one date and whereabouts unknown. That date was January 10th of 2020. A notice was issued and a hearing was held on February 25th of 2020. That's not the hearing that we're here for today. In that hearing, Mr. PEREIRA admitted to not being available on that one date and the whereabouts unknown, and he was reprobated or put back on probation. At that time, new conditions were issued. That's important to our hearing that we're here for today, because sometime later that notice was incorporated into the new notice. So in March of 2020, he's on probation. He gets picked up for a new offense in Dorchester. He's held out of Suffolk County. In April of 2020, the probation officer in Brockton learns of this arrest and learns that he's being held and issues a new notice. The new notice is a copy of the prior notice, which Mr. PEREIRA already admitted to and which he was already reprobated for, and includes the January 10th date as the failure to appear. That's important because it's our position that there weren't any new technical violations, just the two new offenses. So Mr. PEREIRA is being held in Suffolk County. Ms. Gilrain, the probation officer, issues this new notice. At some point, due to COVID protocols, Mr. PEREIRA is released to home confinement. Not released, he's not released and told to report to probation because he's on the street. He's released by Suffolk County because of the COVID protocols in South Bay, I believe, and was released to home confinement. At some point, an incident occurs in October of 2020 in the housing complex where he is confined to home confinement, and a new case pops up in West Roxbury. He's brought in, he's readmitted to Suffolk County Jail. At that point, probation officer Gilrain issues a new notice. He's brought over to Brockton. In October, he's held until a final hearing on the probation in December. November 12th, she issues a new notice. That new notice just basically types in on the old notice the new offense. So now you have two new offenses typed in on the old notice, which there was a full hearing on in February. I went into that much detail about the prior notices because it's important, because with regard to the admission of hearsay and crediting hearsay as reliable, it's important in that if the only basis for the violation is the hearsay, it has got to be a specific finding that the hearsay was substantially reliable. Under Rule 7 of the district courts. It's our position that the only basis of the violation was the new offenses. In fact, the judge noted in a hearing judge that there was no evidence presented on the failure to pay, and she credits the failure to report of the whereabouts unknown from the prior notice. With regard to the hearsay statements and the new offenses, there were two new offenses. As I said, he was brought in October, and he was held until a December 29th hearing. 5 subpoenas went out, one for each police officer who wrote the reports and the 3 witnesses who gave these hearsay statements. The hearing on December 29th was held by Zoom. My sister brings up in her memorandum, oh, well, you know, it's not uncommon for people to not go to courts that are far away or not appear when subpoenaed for violation hearings. This was a Zoom hearing. So at the Zoom hearing, the probation officer is asked, well, you know, where are your witnesses and why are they not there? And I think this is telling for the purpose of good cause. Probation officer simply says, well, you know, it's the holidays and, you know, people just, you know, doesn't offer any explanation, doesn't say there was any effort made to reach these people.
Sorry, excuse me. The witnesses who didn't appear were witnesses that were subpoenaed by probation. They were not witnesses who were subpoenaed by your client.
No, the witnesses were subpoenaed by probation. The
Okay.
3 witnesses who gave the hearsay statements that I want to highlight, and the 2 officers who wrote the reports. My client actually had a live witness present who offered countervailing evidence on the hearsay statements, and offered 3 affidavits of witnesses who also contradicted these hearsay statements. And again, that goes to the credibility. But with regard to the first new offense, which formed the basis of the violation, and I would say the sole basis, it's
Why wasn't the police observations of lacerations on the witness's chin corroboration of the witness's statements that your client hit her with the gun?
well, that's a great question. And as I was getting ready for this, I went back and looked at the reports again. Interestingly, and I do apologize, the reports from the West Roxbury case where that statement is contained is not contained in my affidavit, but it is contained in the Commonwealth's affidavit. And if you look at the Commonwealth app, page 42, that's the first mention of any involvement of Mr. Pereira. You'll see earlier in that report, they respond to a complaint of a group of people and a fight. When they arrive, these 2 women and the 2 witnesses who were also subpoenaed say, oh my, you know, this one person, not Mr. Pereira, threw bottles at us. Mrs. Carrera, who is the person whom they observed the cut on her chin, says, I was hit by a beer bottle that was thrown at me. Okay, so the Commonwealth in the violation of probation hearing pays great attention to the fact that, okay, there were firsthand observations by the officer of an injury. Therefore, that's credible or substantially reliable evidence. If you look at the police report, the police report says those injuries were from a bottle being thrown at the witness. So earlier in the report, it says Mr. Rosa is the person who threw the bottle. All of the 3 affidavits from my client, which were submitted without objection by the Commonwealth, also say Mr. Rosa throws the bottle, hits the victim in the face. So the firsthand observations, and the only thing that they can point to as far as the reliability of this totem pole hearsay goes to those statements. On page Commonwealth app 42, you'll see that sometime after this incident, after these 2 are being taken off by an ambulance for being hit in the face with a bottle by another person, they then say, oh yeah, and Mr. Pereira tried to hit me with the butt of a gun. It doesn't say he hit me. doesn't say that she had any injuries from that. And this is a statement that was related from an EMT to the police officer long after he left the scene. He says, one of these people told me this. So not only was it hearsay from the victim to the officer, he didn't observe this conversation. It was said to him by an EMT. Similarly, back in the Dorchester case, which is the other case, again, they arrive at the scene for a fight with a multi-party fight, many people on the scene of the incident. They make no firsthand observations. Everything that they're learning comes from other people at the scene. The allegation there is that, and I'm sorry, I'm getting the two confused. The one that I was talking about, the injury, was actually the Dorchester case. The West Roxbury case is the one where they get a call that somebody displayed a firearm.
Well, but in the West Roxbury case, the judge took the police report de bene until after she heard the testimony of the witness called by your client.
Yes.
Didn't that live testimony corroborate to some degree what was in the police report?
Not to the extent that the live witness confirms what my client says to the police. So in the police report itself, they arrive, somebody says someone displayed a gun. There's no gun found. Mr. Pereira was not there at the time. They didn't make any direct observations of this occurring. What they do is they interview a number of witnesses. Then at some point later, Mr. Pereira comes to the scene. One of the witnesses says, oh, that's the guy who stole the gun or showed the gun or displayed the gun. Miss DePina, and this is a different DePina than the witness in the report, Miss DePina testifies at the hearing that there was a verbal argument between the two. She confirms the statements in the report that there was a verbal argument between the two, denies that there was any physical contact between the two, denies that there was any gun. The gun comes up in that sometime later, a young girl on the scene finds a casing, a .22 caliber casing, in a parking lot of a public housing complex, comes back to the officer and says, oh, hey, I found this casing. Sometime even after that, and again, that's important because of the closeness in time being one of the elements you got to look at for reliability of the statements. Sometime after that, they get a call saying, oh, my nephew told somebody that this person took the gun and hid it in his house. Again, we have layers and layers of hearsay here. No gun was ever found. He was charged with displaying a gun. No gun found on him. No gun ever found in this house where the third party witness tells another person who tells the police. I would suggest that given that there was contradictory evidence presented, no gun, no contact, and nothing was ever found connecting him to any kind of a gun, that the Commonwealth shouldn't be able to rely solely upon these hearsay statements. They were not reliable.
Is he incarcerated right now?
He is not, interestingly, and while I understand it's not dispositive for purposes of this argument, but both of the underlying cases were dismissed. He was not found guilty on either of those cases. And I just thought it was an interesting point to look up, and I did look at it before I came here, because again, it goes to the credibility of the statements made and the fact that even in those cases.
Look at those today.
Excuse me?
We can't look at that today.
No, I do understand that. And I do understand it's not relevant for our argument, but I do think that it bolsters in some manner the argument that I'm making, that the statements in those reports were not reliable. They were not substantially reliable. Clearly, they couldn't proceed in the underlying cases without these witnesses. These witnesses didn't appear at the probation violation hearing, nor did, I would imagine, they appear at trial. Again, I know my time is getting short. But I would just
ask, are you familiar with the SJC's recent case in Commonwealth versus Costa?
I am not off the top of my head.
Okay, never mind. Just keep going.
Okay, I certainly could look at it and supplement if it's something that I hadn't considered.
No, it's all right. It's all right.
Okay.
We've got it.
At any rate, Your Honors, I would just like to say that it's my position, again, based on the history of the probation violations and how these notices were issued, that the sole basis of the violation was the reliance on these hearsay statements, and that the Commonwealth should not have been relieved of presenting these live witnesses. The judge should not have relied on these hearsay statements, that my client was denied his constitutional rights to cross-examine these witnesses, that the statements were not substantially reliable, and there was not a good showing as to what good cause there was for these witnesses to not appear. And you need both. The statements both need to be reliable, and there's got to be a showing of good cause as to why these witnesses didn't appear. And I would say that's the most blatant problem here. The best that we have is a statement that, well, you know, it's the holidays and people may not come. I would suggest that that's not good cause. I would also suggest that looking at, in my record appendix 28, the form that was filled out by the judge after the violation, there was no written findings that the hearsay was reliable. I mean, these forms literally provide about 6 boxes where the judge can check off and say, I found the hearsay to be reliable. And there weren't even any boxes checked off, never mind the written findings. And I'm out of time. I appreciate that.
Your time has expired. Thank you for your argument. And but you can't see us, but Attorney Anderson, please proceed.
Good morning, Your Honors. Audrey Anderson for the Commonwealth, if it pleases the court. I guess we need to start with the police statements, unless Your Honors have something else that you want to get into first. But the first police statement that was in Boston, the statement was that the Miss Hall and Miss Carreras were struck by Mr. Santos with a bottle. Miss Carreras left. They called the police. Called an ambulance, and she said that Mr. PEREIRA had tried to strike her with a butt of a gun. That wasn't another police officer saying that, oh, this witness told us this. She told the officer herself that she had been struck with the butt, that he had attempted to strike her with the butt of a gun, and she was bleeding. In the second report, I don't want to say it's a witness. I want to say it was a reporter. There was a big party going on, and a person reported that a man in a red shirt and dreads had pulled out a gun and left. The officers found the probationer. He came back. The witness pointed the probationer out, and she also pointed out who he had pointed the gun at. He didn't point the gun at her. He pointed out who he pointed the gun at in the direction that he had went to. Also, her nephew told her that another man had hid a gun in the house. We don't have any information that there was a search of the house for a gun. The only information we have is that there was a .22 caliber bullet found in the parking lot. That's the only information that we have on that. But when you look at the Hartfield factors, you can see some of that this was current information. One of the witnesses was basically disinterested. She was a witness. She wasn't a person that was threatened. The incidents happened, can't say that word, contemporaneously, almost to when the police came. The officers gave detailed reports. It just wasn't a flash in the pan report that something happened. They gave details of going to the hospital, of the injuries that were found, of the defendant was driving the truck and they left. The gun in the both guns. This information was given. And
I have a question for you about the Dorchester incident in March of 2020. It looks to me as though the defendant was charged with assault with a dangerous weapon, not assault and battery with a dangerous weapon. So why is it that we think that she was hit with the gun rather than with the beer bottle by the other guy?
I think he was charged with assault, and I'm not saying that he was hit by the beer bottle. I said that she said he attempted to hit her.
With the gun?
Yes, that he attempted to hit her with the gun.
So if he only attempted to hit her with the gun and he was charged only with assault, do the lacerations on her chin and behind her ear corroborate the charges against him, or do they corroborate the charges against the other guy who threw the beer bottle?
I don't know where he hit her with the beer bottle, but I would say that she got an injury because I don't think he threw it at her. I think he hit her in the face with the beer bottle. And the defendant.
This defendant?
No. Mr. Santos. Mr. Santos hit two women in the face with bottles.
Right. So does the police report stating that Mr. Santos hit someone with a beer bottle corroborate the allegation that this defendant tried to hit somebody with a gun?
No, her testimony, her telling the police that he tried to hit her with the gun. I think that's the corroboration.
Well, that's the complaint. This is Judge Sullivan. That's the complaint. We're looking to see where in that police report there is any corroboration of her complaint.
Only that she was upset and that she was wounded, but I can't say definitely that she was wounded by the gun. I mean, she could have been hit, everything was fast, but she said he attempted to hit me. So I'm working with what I have. He said he attempted. So I have to go by that.
Understood. This is Judge Sullivan again. So is there any other form of corroboration in the affidavits or the police reports related to that date?
Related to the assault?
Yes.
That's really all I have for the assault.
Thank you.
In the West Roxbury, it's a little more.
Attorney Anderson, this is Judge Blake. If I could ask you, at page 22 of your brief, you basically suggest that the defendant had the burden of asking for a capias or a warrant or something like that for the witnesses that didn't show. Do you have any, it starts at page 21. Do you have any cases that say that that's the defendant's burden?
No, I don't. And I'm not sure that it is the defendant's burden, but if the defendant was so concerned about it, my thinking in writing the brief was that he could have requested it. I mean, there was no.
So to request witnesses that potentially would put him in jeopardy.
Yes.
I just want to understand the argument. That's all. I hear you.
The defense did not make any complaints about the witnesses not being summoned. The probation office stated it's summoned sent assuming the holidays.
But the defense did object to the admission of the hearsay.
It mentioned to the two police reports. That's what with my reading, that's what he objected to, was the two police reports. Are there any other questions?
Seeing none, We have no further questions. If you'd like to wrap up, or you may rest on your brief.
I think I'll rest on my brief because it's a pretty lengthy brief. And when you start looking at the appendix, it can get convoluted unless you're looking at the appendix and the probation violations together.
All right.
It's easier to look at them together. But I thank you, honors, for your time. And I just wanted to say thank you. It's been a pleasure.
Thank you.
Thank you both very much. That concludes our argument today, and it also concludes our sitting today. And once again, we'd like to thank everyone who was involved in making this remote hearing possible, including our IT staff and the clerk's office. We wish you all a good day.